Hello everyone, my name is Daniele Gallo. I'm professor of law at Lewis University in Rome. Let me thank very much Diritti Comparati for this amazing opportunity to present my book. The volume is on the ret effect. The title is The Ret Effect in EU Law. It has been published by Oxford University Press under the EU Law Library series in January 2025. The book aims at investigating the ret effect. Most notably, it aims at revisiting the past, present, and future of the ret effect in EU law. In so doing, it offers an hopefully innovative understanding of this revolutionary doctrine from historical, theoretical, doctrinal, and practical perspectives. The volume explains that the ret effect has evolved into a broader legal category than it was at the outset of the process of European legal integration in the 60s. In this respect, the idea underpinning the book is that such evolution has not been properly acknowledged, articulated, and systematized by the Court of Justice, and that the ret effect lacks, for this reason, nowadays a clear legal framing by the court as to its core components and consequences. In this connection, the aim of the book is to reconstruct the ret effect also beyond the Van Gendel-Loss doctrine and ultimately submit solutions for its appropriate understanding and enforcement. The volume is divided into four main thematic sections. The first section focuses on the origins of the ret effect before Van Gendel-Loss, as well as on the interplay between the ret effect and the preliminary ruling procedure governed by Article 267 after Van Gendel-Loss. In that regard, I attempted to demonstrate why the Court of Justice does not only exercise a monopoly over the interpretation of EU law, but has also come to perform de facto a centralized judicial review of national legislation. As for the remaining three sections, thematic sections on the doctrine of the ret effect today, the volume makes the following 10 intertwined arguments that I will put forward now in a rather apodictic manner, for which, of course, I apologize in advance. So, first argument, the test on clarity, precision, and unconditionality is no longer a pillar in the conceptualization and the practice of the ret effect, as can be inferred from the EU case law, where the Court of Justice applies the three criteria vaguely and without steady guiding principles. Second argument, clarity and precision are absorbed in the premise of unconditionality, and for that reason, unconditionality is the only true core element and condition sine qua non of the test on the ret effect. In other words, if a norm is clear, precise, it is not necessarily unconditional, while if a norm is unconditional, it is in re ipsa clear, precise. Third argument, if unconditionality means that the norm is self-sufficient since it does not require an additional act of transposition, unconditionality equals direct applicability, since direct applicability / unconditionality by absorbing the conditions of clarity and precision is the only premise of the test on direct effect. Direct effect and direct applicability, albeit conceptually distinct, end up being in practice the same thing. This implies that aside from issues of terminology, the boundaries between regulations on one end and on the other, direct effective unimplemented directives are, on closer inspection, very thin, even invisible. Fourth argument, direct effect is a broad notion. not necessarily associated with either the conferral of rights or substitutive effects. Hence, the direct effect has two facets. Aside from a subjective substitutive form of direct effect, there exists an objective exclusionary manifestation of direct effect. Indeed, advocating for a broad understanding of direct effect has evident practical implications since it expands the scope of intervention of direct effect, most notably the extent of the duty to disapply. Fifth argument, the duty to disapply is always the result of both primacy and direct effect, never primacy alone. This has been asserted by the Court of Justice for the first time only in Poplaski, as we know. However, no reason has been offered by the Court of Justice in that regard. In the book, I argue that direct effect shall be always there in order to trigger the duty to disapply. Why? Because direct effect ensures that the EU principle of conferral and the related principle of subsidiarity are not called into question by a wide proxy to EU institutions, by, let's say, a generalized, unrestrained use of the principle of primacy. Sixth argument, a paramount quality of direct effect, along with unconditionality, is the attribution of an advantage resulting from the application of EU law and the subsequent disapplication of national law. In other words, the disapplication stemming from EU directly effective provisions cannot be detrimental for all private parties to the dispute, that is only in malam partem, with the result that the admissibility in practice of inverse vertical direct effect not only in respect to directives but also with respect to EU primary law shall be handled with utmost care. Seventh argument, it is possible to come up with a tentative list of physiological derogations from the duty to disapply. These are the physiological derogations because they have been declared admissible by the Court of Justice. Of course, the most relevant one would be Article 4.2 of the Treaty of the European Union as interpreted by the Court of Justice. Eighth argument, recognizing directives or horizontal direct effect is a more suitable route than the judiciary-based, very complex and not easy understandable stratagems designed by the Court of Justice to bypass the provision of horizontal direct effect of EU directives. The principle, though not only reason for admitting horizontal direct effect of directives, is the principle of legitimate expectations. In fact, such principle is not only relevant, it is the narrative, of course, for the person who, the main narrative for the person who conducts oneself in accordance with national rules contrary to EU directives, but the principle of legitimate expectation is also key from the point of view of the person who complies with a new unimplemented directive. Ninth argument, the narrow conception of international law's direct effect within the EU legal order advocated by the Court of Justice is justified in political, not legal terms. Here, the realm is that of direct effect of international law, mainly of international agreements within the EU, rather than looking at the relationship between EU law and national law. Well, in this field, to me, the legacy of the Court of Justice is very much imbued with political connotations. An example is the choice made by the Court of Justice to rule out that the Fediol-Nakajima doctrine constitutes a form of direct effect, albeit being a means of legality review. The court's appreciation of direct effect as a precondition for challenging EU acts is also political. Well, this approach has little to do with the profound legal characteristics of direct effect. Then, final argument, the jurisprudence of the Court of Justice is very often vague, imprecise, unpredictable, too minimalist, at times inconsistent. This form of judicial self-restraint is as problematic as judicial activism. It does vital that the Court of Justice exercise its interpretive monopoly on the ifs, when, and hows of the ret effect by reasserting its constitutional role in shaping the primus inter pares principle par excellence, that is the ret effect. The attempts outlined in the 7 chapters of this volume aimed precisely at identifying solutions to strengthen the ability of the ret effect to pursue its twofold purpose: safeguard, safeguarding individuals' rights and ensuring the private, correct, proper enforcement of EU law. Thanks so much.